would be. Yeah. And would it end at the time of filing the lawsuit, or would it continue after?
The time of filing my lawsuit?
No, when would the timing end for these documents? What would be the time?
Up until the client representation was terminated.
Okay.
Yeah.
So from the beginning of the representation by the defendant through the time of the termination of the representation.
I respectfully, Your Honor, that's one way to do it. I would like to do it a different way. I would like to get detail on all this. It should be no more than an hour, 90-minute deposition of a basic, just fundamental, where are your documents, where are they stored? This is a procedure I've followed in other big litigations.
But before you do that, why wouldn't you have an affidavit to at least start with? And if you think the affidavit's deficient, then maybe I give you a deposition. But don't you at least want a starting point of what they did or didn't do?
Like I said, I'm fine with that, Your Honor. If that's the way you prefer to guide it to resolve this, I can live with that. But I don't think there's any reason to not provide a brief deposition that will guide and make discovery more efficient. So I don't have to send broad requests for production and broad non-uniform interrogatories.
The thing is, though, I'm going to hear from Mr. Stern in a minute, but he's going to tell me they don't have a 36B person or 30B6 person, or if they do, they're going to have to prepare the person. I mean, isn't it better for them to just find the person who did the search? I mean, I don't know. Look, however you guys want to do it, but it seems to me there's different ways to skin the cat. That's just one of them to at least get started and put the burden on the defendant who's saying we searched and can't find him. Okay, well, tell us what you did. Tell us what you searched. Tell us what you find and didn't find. And then we'll go from there. And if we need Moskowitz back or a special master or whatever, then we'll go that route. But it's different. It's one thing to say, oh, we looked, we didn't find anything. Well, who looked? And what did they do? And, more than just we looked, and it's now maybe that was done, Mr. Sturr. I'll hear from you.
Thank you, Your Honor. Jeffrey Sturr on behalf of the defendants. If I may first respectfully just briefly state, we don't think the file's relevant because this is a legal malpractice case subject to the case within a case standard. We've admitted liability for the dismissal of the action, and now it's up to plaintiff to actually put on the underlying case, which is they have to prove the defendants in the underlying case were negligent, that there was damages, and that they were collectible. So all of that evidence, Your Honor, is in the possession of the plaintiffs and the defendants in the underlying action. We have, Your Honor, fully produced the file that was maintained by the firm. At Mr. Coombs' request, we went back and did an additional search to try to find documents. What we're really talking about now, Your Honor, is what is driving this, I believe, is the associate in the underlying case kept time records, and there are documents referenced in the time records that are not in the file. We've looked for them. We can provide in a simplified way, as you've suggested, through an interrogatory or a declaration as to the steps that were taken to locate the documents and whether they exist or not. Ultimately, he can depose the associate attorney and ask about those issues. But I just want to make two things clear. We have done everything we can to search for the file and produce everything. We believe the complete file that's in the possession of the law firm was produced. And I think your suggestion, Your Honor, of a simplified method of answering this narrow question is, why are there documents that were referenced in the time entries that are not in the file? We can deal with through an interrogatory or some other discovery device rather than a 30B6.
Let me ask another question, because you raised a good point. Why, Mr. Combs, is the law firm's view of the case value? I mean, why do you need the documentation about that? I mean, you've already got the certificate of compulsory arbitration that says the case is not subject to, so that shows it's worth more than 50. I'm sure you could depose the attorneys, or maybe not. Maybe the attorneys are gone. Are you able to depose any of the attorneys that worked on the case?
Well, I certainly plan to, but I need the documents first.
Right, but can't you ask them what they thought the value of the case was?
Right, but it helps to have what they thought at the time in writing, so they don't just say, "Yeah, oh yeah, it was only 50,000. That's what we were going to do," but their memos might say something to the contrary.
Okay, but what relevance or what probative value is what they thought the value of the case was, if you have to prove the value of the case with the case within a case? I mean, the damages are the damages. I guess, are you saying just for credibility and impeachment purposes, if somebody says, "Oh no, it wasn't worth that much"? I mean, don't you have to prove the case within the case?
Yeah, but it's not necessarily a black and white thing. If there was arguments for to go around the coverage or bad faith, or they had different arguments, I don't know what I don't know, Your Honor. I've got 8 pages of correspondence, not a single internal document from this firm.
Remind me what the underlying case was about.
It was a car crash.
So you'd have to prove that the person was injured in the crash and they sustained damages.
My client inarguably suffered catastrophic damages in the case. There's some comparative fault issues, but that gets to another thing. What was there? Now they say, oh, he was going to be 100% at fault. Well, you didn't say that when you were pursuing the case for 2 years.
Who's going to say this? Who's going to say all this? That the case isn't worth much and it's comparative fault. Who's saying that?
I presume the defendants, but I need their documents to cross-examine them.
What witness?
I don't know. That would be for
Isn't that in the disclosure statement? I mean, how are you getting this information that that's their position?
That's been their position in their disclosure statement. And
what witness is going to testify to that?
I don't know. You have to ask Mr. Sturr.
Well,
but I presume it's going to be there's a coverage denial letter, so he's going to have his witnesses talk about it, or maybe he's going to call the defense in the underlying case people to talk about it. But I need to get this law firm, it's a legal mal case. I need to get their file, which they should have produced under their ethical duties to their client anyway. I need to get their full file so I can properly assess this case.
Your Honor, if I may step in, sorry.
Yeah, go ahead.
The case within a case, if I don't know if you've had legal malpractice cases or not, but under the case within a case doctrine, particularly here when we've admitted liability, the underlying case gets tried anew. The defendant in the law firm in the case stands in the shoes of the underlying defendant to raise defenses that would have otherwise been raised. What happened in this case was after it was taken on, it was determined that the adverse driver, who was rear-ended, by the way, on the HOV lane by the plaintiff, and claimed that the plaintiff was at fault. The adverse driver had only $50,000 of insurance under his policy. And that was discovered during the course of the underlying litigation. There is a rental company. He was trailering a boat. There was an investigation into whether or not there was liability on the part of the rental company. And ultimately, it was determined there was no coverage. There's a coverage denial letter, and there's a declaratory judgment action in Utah saying there's no coverage. So at this stage, it's the plaintiff's burden to prove that they would have prevailed in the underlying action and the amount of damage. The recoverable damages, however, Your Honor, are limited as a matter of law to whether it was collectible. So we have already disclosed in our disclosure statement that the adverse driver had only $50,000 of insurance. He's essentially judgment proof. We've produced records of his assets. So that's what this case is about, Your Honor. That's why we say it's a $50,000 case.
Is collectability, in the case within the case doctrine, is collectability irrelevant?
It is completely relevant, Your Honor. And we've cited in the memorandum to you in this discovery dispute, the restatement third of the law governing lawyers, which applies in Arizona, recognizes that collectability is an issue. It imposes on the defendant the duty to raise the issue of collectability. The burden of proving collectability, however, is always with the plaintiff. So we've met our burden. We've established that no matter what, if he could prevail and establish that he, after rear-ending someone, could recover from the other driver, that the most that could be recovered is whatever could be collected from that driver. And so we put on that evidence at trial, Your Honor. We would put on evidence of the coverage, the lack of coverage, the steps that were taken to determine if there was any coverage at all. And we would, through the testimony of the adverse driver, establish that he had no, he'll deny liability, of course, but that he had no assets from which a judgment could be collected.
So in the end, there's nothing to recover, or there's $50,000? I missed that.
$50,000, Your Honor, if he can establish that the adverse driver who he rear-ended was at fault.
Well, then I guess that begs the question: why did your client file the lawsuit to begin with? And that begs his question, which is, then why'd you file the lawsuit saying the case was? But what were you thinking? Like, what's the strategy? What was the strategy? And he wants the documents.
Yeah, happy to answer that, Your Honor. The plaintiff in this case was represented for 2 full years after the accident by an out-of-state lawyer named Ace Blackwell. Mr. Blackwell worked up the case, sought out local counsel, and that's how my client was retained to serve as local counsel for an out-of-state lawyer. Mr. Coombs has access to all of Mr. Blackwell's files, everything about the strategy and the thinking about the value of the case. At the time,
He has that?
he does. And at the time, Your Honor, when my clients took on the case, they didn't know what coverage was available. And the discovery about the limitation on coverage and available assets and liability, frankly, didn't occur until after the action was filed here in Arizona.
Is Ace Blackwell sued?
We have named him as a non-party at fault, Your Honor.
All right, so what did you say that plaintiffs have again? You said they have whose understanding of the case?
We have Mr. Blackwell's entire file. Mr. Blackwell, as I understand it, has been consulting with Mr. Coombs and has all of his notes, emails, all of his communications with my client, with the client. That's been produced by Mr. Coombs. So that's already in the file. And then separately, Mr. Coombs has my client's entire file.
Except for the things that he says are missing.
Except for the documents that were not identified, they're not located in the file when it was gathered and produced. And if I may, Your Honor, those documents, it was an associate who had the lead as local counsel. He made some time entries that referenced documents, and we have not been able to locate the documents that are referenced in his time entries.
Is he still with the firm?
He has left the firm. He left the firm at about the time the case was dismissed. He's a named defendant in this case, Your Honor. I am representing him together with the law firm and the other named lawyer defendant.
Well, you tell me, Mr. Stir, what makes the most sense here? To get a declaration from your clients, plural, that addresses these topics, and what you guys did, to find. Is it just what was referenced in the billing statement that wasn't found, Mr. Combs, or are there other documents you think?
I have 8 pages of quote unquote correspondence, which is not a single internal email, much less notes, reports, memos, nothing internal at all. I don't even have externally other than 8 pages.
What do you mean 8 pages?
I'm sorry?
You have 8 pages. What do you mean?
In what they disclose, there's a folder, correspondence, there's PDFs in there that's total 8 pages. That's all I have for all the internal and external communications for a law firm that worked on this for 2 years and billed 200 hours. That's just ridiculous.
Yeah, if I may, Your Honor,
respectfully.
I think Mr. Coombs is mistaken. We did produce at the time the representation ended at the request of Mr. Blackwell. The firm provided an entire copy of the file, electronic copies, emails, etc., including internal communications. It was provided to Mr. Blackwell and the client at that time. Mr. Coombs subsequently asked me to search for additional documents, which I did. What he's referencing are the additional documents that we found. But I will represent to you again, Your Honor, the entire file was produced, which includes internal communications.
Respectfully, Your Honor, it does not. It does not contain communications between lawyers, which happens on a daily basis with staff, with paralegals, which happens on a daily basis on a case like this. And it doesn't contain any memos or analysis or notes or anything like that.
Is there like an intra-law firm database where, they can either through Teams or some other communication system send notes to each other about cases? Are there emails?
This is exactly what I wanted a deposition to find out, Your Honor.
There are emails, Your Honor. There are also emails extensive emails, if I may say, with Mr. Blackwell, who was lead counsel as we see it in this case. They are in Mr. Blackwell's production, and they're also in the law firm's production.
So you have that?
Yes, I do. I have the full file from it's Blackburn, but yes.
So, thank you, Link. Sorry about that.
And your client would have communications with the lawyers too, right?
Not very much. My client's got a traumatic brain injury and not an emailer.
Okay. Right.
Respectfully, Your Honor, the only issue I foresee, they'll get a declaration, say, we looked for it, we didn't find anything, and we'll be right back here,
Oh, you'll be with
in
a special
30
master.
days.
You'll be with a special master.
Well,
That's what you're-
maybe. I might need that in this case.
Yeah, no, it sounds like you do need a special master.
Your Honor, if I may, if Mr. Coombs wants to put in writing in the form of an interrogatory.
No, not going to put him to that burden.
Okay,
I think it's
that's
clear what
fine.
he wants. I don't think we need to do any more of that. I
Okay,
think it's clear what should happen. If you're saying you've done a search and you couldn't find it, then it needs to be detailed to start with, an affidavit from who did the search, what they searched, what was available that they didn't search, what could still be searched, what was found, what wasn't found. And once that's done, Mr. Coombs will either accept that or won't accept it. Assuming he doesn't accept it and he's right, and you guys still disagree, then you'll come back, you'll give me the names of a special master. We will split the cost initially, subject to reallocation for the cost of that special master. And then the special master can dig into the weeds if that's how you guys want to do this. So I just think, there's a lot of weeds to dig in here. I don't know all of the available avenues of what there would be to search for. I don't know what was searched. But it seems to me someone ought to know at the firm. These are all the things that you could search for: email, interoffice, intra-office, written notes, electronically stored notes. I mean, this isn't secret stuff. We all have been at law firms. We all know how this stuff works. It's kept certain ways. And I think there might even be rules on what needs to be kept and what shouldn't be kept and what can be thrown out. If you lose a client, I remember when I was a lawyer, there were rules on what you had to give the client and what you didn't have to give the client. I forget what had to be stored and didn't have to be stored, what you had to do with your notes, what you didn't have to do with your notes. So I just think, Mr. Sturt, there's got to be someone there that can start off with a declaration saying, these are all the possible things to search. This is what we searched. This is how we searched it. This is what we found. This is what we didn't find. Start there. And if that doesn't answer it, come back to me with 3 names apiece. I'll roll a die. Or if you agree on a special master, let me know. Give me a proposed order. I'll get you to the special master. Each side will pay half of the special master, and the special master can reallocate as he or she sees fit, depending on, what ultimately is determined to be appropriate given each side's position and what was recovered, Mr. Combs, or what wasn't recovered. So anyway, go ahead, Mr. Sturt. I didn't mean to interrupt you.
not at all, Your Honor. I think I think that's a sensible suggestion, a very pragmatic one. I think I understand what Mr. Coombs would like to see in the form of a declaration, which would describe the steps the firm took to turn over the file when it was requested. And by the way, that's Ethical Rule 1.16, and the subsequent steps that were taken to locate additional documents, and with reference to the documents that were produced, and it would reference the steps that were taken through all the firm's records to comply with that ethical obligation and to the subsequent request for the file.
I also just think it should include, what is available to search for.
It would include that information, Your Honor. That's what I meant.
What the firm has, because each firm may have different ways of communicating intra-office, right? I don't know about intra meaning inside the firm. And then obviously external communications. But I think Mr. Combs is really looking for the internal stuff, is what I think he really wants. So do you want him to focus on the internal office communications, what's available?
Internal communications and the internal notes, memos, analyses, etc.
Right. And then, Mr. Sir, also please add if there are limitations ethically or otherwise, or policies that the firm has as to why they keep certain things for a certain period of time, but don't keep other things for a certain period of time. That may explain why they have some things and not other things. I think that might be helpful to Mr. Combs to know as well, and might end further disputes that may arise if things just don't exist because either by policy and procedure or ethical rule, we don't keep them for a certain period.
I also would like full billing records. The only billing records I have are from a submission to the either Court of Appeals or the trial court, I can't remember, that they attached as an exhibit to show that they were otherwise being diligent when they allowed the case to get dismissed. So
Billing
I don't have a full set of billing records.
Billing records. So
if I-
plaintiff's firm is billing? I'm confused. Was it
It's a
contingent?
full service commercial litigation, and
Not a contingent case?
this may have been a contingent case. I can't remember exactly. I think it was, but
Disturb billing records?
yeah,
Your
I've
Honor,
got
One at a time.
partial.
It was a contingent case, but the firm did as many contingent cases. They did record time, the associate recorded time. And Mr. Combs may have forgotten, we did produce the unredacted complete set of billing records some time ago. He has those.
Okay, maybe I do have those then. I apologize.
Fair enough. Yeah, I get it. You could still bill just to, if you wanted to show at the end why your contingency fee was reasonable and you kept time, you'd at least have how many hours.
We did it at my old firm. We still had to keep track of all our time,
Yeah.
even though I was almost completely on contingent fee.
Right. All right. Well, hopefully, Mr. Sir, that gives you the idea of what to try and get in terms of an affidavit. I don't know if that makes it more efficient for you, Mr. Stir, to do that. I was trying to look at this pragmatically, practically, and efficiency-wise. I was hearing from you that it might be difficult to get a 30B6 deponent that can answer all that. I'm hoping that you can get an affiant or maybe two that can address all this, but I'm sure somebody did this work, right, when requested?
Oh, yes, Your Honor, our issue was not about the affiant. It was about the cost and expense of a 14.30B6 deposition. That's what brought us to you today. The affiant would be the managing partner of the firm who was responsible for the production. He can easily do that. If I could, you haven't set a deadline, Your Honor, but I'm wondering if I got it until, well, if I may, when you think about the deadline, we have a mediation scheduled for next Wednesday, August 5. And I'd like to have some additional time after that to provide the declaration.
Any objection?
No objection, Your Honor. And just one qualification. I'd like to make sure whatever affidavit, he represents Mr. Gumby. He's not at the firm anymore. And there's kind of this, well, he left. We don't know where all his stuff is. That needs to encompass all of Mr. Stir's clients. If I don't know who did the search for Mr. Gumby, if it was, he's just talking about the managing partner of the law firm defendant that Mr. Gumby is no longer with.
That could be included. I have already worked with Mr. Gumby. We've produced, in fact, Lincoln, you may have forgotten, we've produced some of the records that Mr. Gumby has.
Yeah, and so if he's got nothing else and he searched, then that could be, I guess, an affidavit from Mr. Gumby that he's got nothing else.
So, Your Honor, I proposed August 14th, if that's acceptable to you and Mr. Coombs.
I have no skin in the game.
Yeah, that's fine. Thank you.
All right, so by August 14th to get the affidavit or affidavits, because Mr. Coombs, I guess you'd like to have something from Mr. Gumby, is that right? Gunby, just saying, you know, he doesn't have any of his notes. He looked, he has no notes, he has no internal communications, he has whatever. Yeah.
Whoever did the search for the documents he authored.
He authored. Right,
According
including
to his
himself,
timesheet.
because I don't know what he took with him when he left. I have no idea. I don't know
Neither
why he
do
would
I.
take anything,
Neither do I.
but maybe he did, maybe he didn't. But if Mr. Stir can get an affidavit from him saying he's got nothing, that should at least address that for your purposes.
I left a similarly sized law firm 6 years ago myself, and I know what it's like when you leave a law firm like that.
All right, and if there's any further disputes, well, let's do this. If there's another dispute following up on this, do a 26D, keep it short, and be prepared to have a special master, but I don't want to blow this disproportionately to a special master if I look at your 26D and it's something I can quickly resolve. So go through this, well, try and settle it. If you don't settle it, then I guess get through this affidavit process. If that's still a problem, do a short 26D to me. If there's still disputes, I'll look at it. And then if I think I can help, I'll help. And if I can't, we'll go to a special master and let the special master dig in deeper. But at least this will be a start.
Yeah.
So whatever that's worth. Anything else, Mr. Combs?
Nothing further, Your Honor. Thank you.
Mr. Stir, anything else from you?
No, Your Honor. Thank you for your
Who's the
time. this
mediation
morning.
with? Who's the mediation?
We're
Miles
mediating-
Hassett.
Miles Hassett.
Oh, okay. All right. Well, good luck.
All right.
All right.
All right.
Stay well. Have a good rest of your day. See you.
Okay,
Thank you.
thank you, Your Honor.
Yeah.